it does not disclose who is the complainant. Is the complainant Mr. William Ruto or is it PL Langat? And this is so important, Your Honor, and fundamentally important and prophetic, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's for you.
Your Honor, if I may.
Yes,
Your Honor, if I may, the charge sheet brought before you this afternoon,
and I see that you don't take a lot of time on this.
yes, I'm only raising one issue. Yes. I'm only raising one issue. That the alleged complainant here is also not a witness. I'm wondering how the two police officers will be the witnesses in this matter, yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you.
Your Honor, I will make a very short statement.
Yes, Your Honor.
I'm Willis Jim. An accused person under Article 50
Yes, Mr.
Under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet if you look at the count one, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceed to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Langat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before Your Honor
Mr. Ocean,
yes.
we don't know whether they are going to be voting this one with blood pressure. So you need just to check on your voice so that
And become like a button. I know sometimes I sting like a bee. The bottom of my video. I'm not ejected. So, Your Honor, that's all I know. The particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's disconnect in the two. So will Mr. Morara be required to respond to the count of cyber harassment or the particulars of defamation? That charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, civil division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to this set free forthwith, unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
very kind commission. Just a moment. If I write everything, if I say the whole thing,
That's what justice is out.
that's the challenge with us lawyers. We are talking to what we don't know. We don't know what we're going to say. So I'll be writing manually because we have not set up the gadgets. We didn't know this case of this kind of coming today. So now just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. So we'll have them transcripted.
Try Pure Active, the #1 anti-pimple cleanser with salicylic acid and charcoal to reduce pimple-causing germs.
And urges to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. You know, that is under Article 25C of the Constitution. Very quickly, Your Honor, I will, with divinity, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be informed of the charge in sufficient detail to answer it. But, Your Honor, what has come out in the few minutes before,
There will be 50 sub
50 sub-article 2B. If I'm not wrong, Your Honor, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J. 52A all through to 50Q, Your Honor, is what constitutes fair trial. Such that, Your Honor, we stand before you this morning or afternoon, the accused person is clearly not able to understand, Your Honor, what is responding to. This is a provision, Your Honor, or this is a right, Your Honor, which cannot be limited. I invite court to find basis on those two articles, Your Honor, to reject the charge that have been read out. That's all from you.
I leave the floor to Milimani.
Yes, Your Honor, I just wanted to say one or two things.
You can start by saying.
Yes, Your Honor, my name is Eric Ulrich. Your Honor, you've been referred to articles to refresh what has been stated. But Your Honor, so that you are not told that this court cannot deal with the questions of constitutional interpretation, Your Honor, I also wish to refer this court to the Criminal Procedure Code, and I would want to make reference to sections 135 with regard to the framing of charges. Section 135 with regards to the framing of charges. And Your Honor, it underpins the constitutional requirements that an accused person is entitled to sufficient information to be in a position to respond to the charges that are made against that person. Your Honor, second, you have the jurisdiction and the discretion under section 89 of the CPC to decline these charges if you are of the opinion, and Your Honor, we persuade you to be of this opinion, that the charge sheet before you does not, in sufficient material, disclose a case to enable the accused person take a plea. Your Honor, I'll finally say it, and I think I have said this before. If we continue at this rate, we will have to seriously expand this course. Because Your Honor, what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country. Sometimes, yes, I can say something that can be offensive, but does that constitute a crime? It's the danger that we face with this kind of touching. For those reasons, and being that these courts are temples of justice, there are games that can be played. And I think it is also important for me to say that this court has recognized, and the High Court, I think, has recognized the manner in which of late police have been conducting their arrests by way of abduction of those people they consider to be suspect. There is actually an order of the High Court that has directed that the police must comply with the law when it comes to effecting arrest. So when someone is abducted, like the accused was abducted, in clear contravention of a court order, and then he's brought here for the court to sanctify the actions, the illegal actions that have been undertaken. And the attempt to sanctify Your Honor, those actions does not meet what is contained in our laws in terms of the kind of charges that should be presented and accepted before the court. Your Honor, this court must remain what it is supposed to be, a court of law. We may not be able to stop the police in the manner in which they are behaving, but they must be a place where they know that they can play their little games outside there with the lives of each and every one of us, because it basically means that no one is safe. I can make a statement that it is deemed criminal. Let them know that those games will not be entertained within the corridors of justice. And so, Your Honor, I plead with this court that we must take all the circumstances of this case, and the circumstances of this case then explain the paucity in the charge sheet as has been presented before.
I think you have managed the report, yes. And it's more than the court directing on this.
Will we call for a short adjournment so that the court is clear and the person has care? They need a short adjournment.
There are some other rooms on the other side that are bigger and more. No, this is the biggest. Wampeleke the other
Thank you. Your Honor, it is the last time we appeared in the court over this matter. The court had to buy me. I was avoiding that because I don't want it to go on record. But it looks like, I mean, at a certain point, we may really need to think about fasting and whatever. But Your Honor, what I was saying is that the circumstances of the arrest and then demonstrate why. Yes, Your Honor. Yes, Your Honor. So my final point was that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest and it will be able to understand that the intention here is for this court to be a conveyor. We abducted him, we were unable to. So Your Honor, what I was saying is that this court is intended to be a conveyor. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is finished. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is fair, and then even this court will eventually almost be on trial the way our police are on trial. You know, for that reason, I'm noting that Mr. Morara had a young counsel that he had instructed. I'll ask that you allow Mr. Samonka to just say one more thing, and then I know all of us would want to say something. I'm being reminded it's also a
Please, Your Honor, my name is Marema. I humbly and wholly appreciate the recognition of my last seniors, and I thank them for the knowledge that I received in the fact. However, there's one small thing that we haven't touched. And briefly, that's to do with the framing of charges under Section 134 of the CPC. as read together with section 135 of the Criminal Procedure Code, which dictates in mandatory terms that a charge must contain a statement of the specific offense in which the accused is charged, and enough information to demonstrate the nature of the offense. Knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer Abuse and Security Act. Specifically section 22 of the Computer Abuse and Security Act. If you go on further on, they repeated the statement, false, again. And then lastly finished with calculated to tarnish and discredit. Calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or civil or defamation? Your Honor, in brief, as I associated both my learned senior counsel Eric Thori stated, I was with Morara when he was being arrested. The police refused to grant me access to Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. Your Honor, the question is, we are dealing with people.
We might all of us end up fainting here. So please, just a request that you allow me to manage the crowd. I'm going to request everybody after the gentleman in the big camera. We're just going to ask you kindly to step out of the room. Otherwise, we can't face here. Please, you can listen from outside. We have speakers. So we'll be able to if your problem is that, we just want to break. Because health comes first. Please, please. But I want to see you counsel speaking.
Oh yes, yes, Your Honor. So
because you can get, there's so many of us are sweating. You can get the smell of sweat. That is really loud.
yes, Your Honor, I'll be brief. Your Honor, in
How
brief,
many more minutes will you take?
3-4 minutes.
Okay, please.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who against all odds stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take leave. Please.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young patriot. to release, to free him completely, discharge him. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, and we will stand with him.
May the court afford exactly 1.5 minutes. My name is Chiel Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, it is a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 23A. That article obligates this court to adopt Article 20 Subarticle 3A. You know, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on the issues he's speaking about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy or alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds.
Just a minute.
Only one about the charge sheet, because it will become relevant for them in response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. That the charge sheet itself is indicating erroneous dates when our client was arrested. They say that they arrested him today. And the fact is that they arrested him yesterday. They have a duty to disclose all the material facts, and there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you seek to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client, as it is charged him. Most obliged.